Warned, in 2002, one of the most respected names in global business vanished in 85 days. Arthur Andersen, a firm that had audited America's books for nearly 9 decades, employing 85,000 people across the planet, ceased to exist. Not because of bankruptcy, not because of a merger, but because of a single client relationship that turned an accounting firm into the largest corporate casualty of the Enron scandal. The question that haunted regulators, employees, and business schools for years afterward wasn't just how it happened. It was why nobody saw it coming, and whether the entire accounting industry had been lying to itself about what auditors actually did. This is the story of how the gatekeepers became accomplices and how the watchdog became the wolf. Arthur Andersen founded his accounting firm in Chicago in 1913 with a reputation for one thing: refusing to bend. The most famous story from the firm's early years, retold in company training for decades, involved a railroad executive who demanded Andersen approve questionable financials. Andersen, barely 28 years old, reportedly told the executive his firm wouldn't sign off on the numbers, even if it meant losing the client. "There's not enough money in the city of Chicago to make me do it," he supposedly said. That story became the foundation myth. Arthur Andersen built itself as the firm that said no when others said yes. By the 1950s, it had become one of the Big 8 accounting firms, the elite group that audited most major American corporations. The firm didn't just count numbers. It positioned itself as a guardian of financial truth, the intermediary between management and shareholders who ensured the books reflected reality. But something changed in the 1980s. Arthur Andersen, the man, had died in 1947, and the firm he left behind began splitting into two competing cultures. On one side were the traditional auditors, methodical, conservative, focused on compliance. On the other side was a rapidly growing consulting division that sold technology implementations, strategy advice, and business solutions to the same clients the auditors were supposed to watch skeptically. The consulting division made far more money per engagement than auditing ever could. An audit might bring in a few $100,000. A consulting contract could generate tens of millions. By the 1990s, consulting revenues at Arthur Andersen had begun to dwarf audit fees, and that created a problem embedded in the firm's entire business model. The people auditing a company's books worked for partners who desperately wanted to sell that same company expensive consulting services. The conflict became so severe that in 2000, Arthur Andersen split into two separate entities. The consulting arm became Accenture. The accounting and audit business kept the Arthur Andersen name and the reputation. But the revenue pressure didn't disappear. Audit partners still needed to grow fees, and one client in particular had become extraordinarily lucrative. Enron Corporation wasn't just another client. By the late 1990s, it had become America's 7th largest company by revenue, a darling of Wall Street analysts and business journalists. Fortune magazine named it America's most innovative company 6 years in a row. Enron's business model, trading energy contracts, building power plants, creating new markets, was complex, cutting edge, and highly profitable. At least, that's what the numbers said. Arthur Andersen had been Enron's auditor since 1985, but the relationship went far beyond typical audit work. Andersen employees were embedded inside Enron's offices in Houston. The firm provided internal audit services, risk management consulting, and technology implementations. In 2000 alone, Enron paid Arthur Andersen $52 million, $25 million for audit services, and $27 million for consulting and other work. David Duncan led the Enron audit team for Arthur Andersen. By all accounts, he was smart, hardworking, and ambitious. He was also deeply embedded in a relationship where Enron wasn't just a client to scrutinize. It was Arthur Andersen's second largest account worldwide, a crown jewel that justified promotions, bonuses, and the firm's reputation for serving innovative companies. The problem was that Enron's financial statements had become a labyrinth. The company used thousands of special-purpose entities, separate legal structures designed to keep debt off Enron's balance sheet. Some of these were legitimate financing tools. Others were shells controlled by Enron executives, designed to hide losses and inflate profits. The accounting was so complex that even experienced analysts struggled to understand what Enron actually owned and what it owed. Arthur Andersen's job was to verify that Enron's financial statements fairly represented its financial position. But doing that job thoroughly would have required questioning transactions that Enron's CFO, Andrew Fastow, had personally structured, transactions that, if unwound, would reveal that Enron's profits were partly fictional. And questioning those transactions might cost Arthur Andersen $52 million a year. Inside Arthur Andersen, some people did raise concerns. Carl Bass, a partner in the firm's professional standards group, the internal quality control unit that reviewed complex accounting decisions, challenged several of Enron's accounting treatments in 2000 and early 2001. He argued that some of the special purpose entities didn't meet the requirements to be kept off Enron's balance sheet. Bass's concerns went to the heart of Enron's financial engineering. If those entities had to be consolidated back onto Enron's books, billions in debt would suddenly appear, and billions in reported profits would evaporate. It would reveal that Enron's growth story was partly a mirage. Enron's executives didn't appreciate Bass's scrutiny. In the summer of 2001, they asked Arthur Andersen to remove him from any involvement in the Enron account, and Arthur Andersen complied. The firm reassigned Bass away from Enron reviews. The partner who had asked the uncomfortable questions was sidelined, and the audit continued. Looking back, that decision marked the point where Arthur Andersen stopped functioning as an auditor and became an enabler. The firm had chosen the revenue stream over the hard questions, but at the time, it didn't seem catastrophic. Enron stock was still trading above $60 per share in August 2001. Analysts still loved it. The machine kept running. Then, in October 2001, Enron announced a $618 million quarterly loss and a $1.2 billion reduction in shareholder equity related to those special purpose entities. Investors panicked. The Securities and Exchange Commission opened an inquiry, and suddenly, the accounting that Arthur Andersen had approved for years was under a spotlight. On November 8, 2001, Enron admitted it had overstated earnings by nearly $600 million since 1997. The stock collapsed. By early December, Enron filed for bankruptcy, at the time, the largest bankruptcy in American history. Arthur Andersen faced a nightmare. The firm had signed off on financial statements that were now revealed to be materially false. Lawsuits were coming, regulatory investigations were starting, and inside the Houston office, David Duncan and his team made a decision that would destroy the entire firm. On October 23, 2001, Arthur Andersen's in-house lawyer sent a memo reminding employees of the firm's document retention policy. The timing was critical. The SEC had just announced its Enron investigation. Over the next 2 weeks, Arthur Andersen employees in Houston shredded thousands of pages of documents related to the Enron audit. Emails were deleted, entire boxes of paper were fed into shredders, and hauled away. Duncan later testified that he understood the shredding was part of the firm's routine policy to dispose of drafts and non-essential materials. But to prosecutors and the public, it looked like something else entirely: destruction of evidence, and it continued even after the SEC investigation became public knowledge until November 8th, when Arthur Andersen's lawyers ordered all shredding to stop immediately. By then, the damage was done. The Justice Department began a criminal investigation, not just of Enron, but of Arthur Andersen itself. In March 2002, the firm was indicted on charges of obstruction of justice for shredding documents related to the Enron audit. The indictment was a death sentence. Under Securities and Exchange Commission rules, a convicted felon cannot audit public companies. If Arthur Andersen were convicted, it would lose the legal right to do the work that justified its existence. Clients began fleeing immediately. No public company wanted to be audited by a firm under criminal indictment, especially one tied to the biggest accounting scandal in a generation. Delta Airlines left, Merck left, FedEx left. Within weeks, Arthur Andersen lost more than 100 major clients. The firm's international partnerships began severing ties and joining competitors. The Big Five accounting firms were about to become the Big Four, and Arthur Andersen's 85,000 employees worldwide faced unemployment. Arthur Andersen's criminal trial began in May 2002 in Houston, the same city where Enron had collapsed. The charges were narrow. The firm had obstructed justice by shredding documents with the intent to impair an official investigation. The government didn't have to prove that Arthur Andersen had approved fraudulent accounting, only that it had destroyed evidence. David Duncan pleaded guilty to obstruction charges and agreed to testify against his former employer. His testimony was damning. He described a culture where keeping Enron happy was paramount, where concerns about accounting were dismissed, and where the shredding was clearly tied to the SEC investigation. The defense argued that the document destruction was routine, that no one intended to obstruct justice, and that the firm was being scapegoated for Enron's fraud. But the jury didn't buy it. On June 15, 2002, Arthur Andersen was convicted of obstruction of justice. The conviction meant Arthur Andersen could no longer audit public companies in the United States. The firm's remaining clients scattered to competitors. By August 2002, Arthur Andersen formally ceased practicing as auditors and accountants. An 89-year-old institution, one of the most respected names in global business, had been obliterated in less than a year. But the story didn't end there. In 2005, 3 years after the conviction, the United States Supreme Court unanimously overturned Arthur Andersen's obstruction conviction. The court ruled that the jury instructions had been flawed. They allowed the jury to convict even if Arthur Andersen hadn't knowingly intended to obstruct justice. Chief Justice William Rehnquist wrote that the instructions were flawed in important respects. It was a complete legal vindication, but it was also completely meaningless. Arthur Andersen had already been destroyed. The 85,000 jobs were already gone. The clients had already moved to other firms. The international partnerships had already dissolved. You can't resurrect a company 3 years after it dies, even if the Supreme Court says the execution was improper. The Enron prosecutions, meanwhile, moved forward. Kenneth Lay and Jeffrey Skilling, Enron's top executives, were convicted of fraud and conspiracy in 2006. Andrew Fastow pleaded guilty and cooperated with prosecutors. The Enron scandal became shorthand for corporate greed and accounting fraud, studied in business schools as a cautionary tale. But Arthur Andersen's collapse raised a different question, one that made regulators and lawmakers deeply uncomfortable. If one of the Big Five accounting firms could be destroyed overnight, what did that mean for the entire system of corporate accountability? In July 2002, Congress passed the Sarbanes-Oxley Act, the most significant overhaul of corporate governance and accounting regulations since the 1930s. The law created the Public Company Accounting Oversight Board, a new regulator to oversee auditors. It required CEOs and CFOs to personally certify their financial statements. It banned accounting firms from providing certain consulting services to their audit clients, trying to eliminate the conflict that had compromised Arthur Andersen. The reforms were sweeping, but they didn't solve the fundamental problem. Auditors are hired and paid by the companies they audit. The structural conflict of interest remains embedded in the system. An audit partner who loses a major client faces career consequences. An audit partner who keeps a client happy, even if that requires bending judgment, gets rewarded. And Arthur Andersen's destruction created a new risk. The Big Five became the Big Four: Deloitte, PricewaterhouseCoopers, Ernst & Young, and KPMG. These four firms now audit nearly all major public companies worldwide. If one of them were to fail or be indicted, the disruption to global capital markets would be catastrophic. Regulators effectively face a too-big-to-fail problem with audit firms, a recognition that destroying another major firm might do more harm than good. even if misconduct is proven. That's created what critics call audit immunity. Since Arthur Andersen's collapse, no major accounting firm has faced criminal prosecution, even when serious misconduct has been alleged. Instead, regulators impose fines and settlements that don't threaten the firm's existence. The lesson learned wasn't hold auditors accountable, it was never destroy another major firm. Today, a small remnant of Arthur Andersen still exists, a skeleton crew managing lawsuits and claims from the Enron era. The name occasionally appears in legal filings. Former employees scattered across the accounting industry, many hired by the Big Four firms that absorbed Arthur Andersen's clients and talent. But the firm's collapse left a permanent mark on how American business thinks about accountability and gatekeeping. Arthur Andersen was supposed to be the skeptical outsider, the professional who verified that management's claims matched reality. Instead, it became a business partner so entangled with its client that it couldn't perform the one function that justified its existence. The Enron scandal revealed something uncomfortable. The entire system of independent audits depends on a polite fiction. We pretend that auditors work for shareholders, protecting investors from managerial misconduct. But auditors are hired by management, paid by the companies they audit, and dependent on keeping those clients happy to stay profitable. Arthur Andersen's failure wasn't an aberration. It was the logical outcome of a system with a built-in conflict of interest. Some former Arthur Andersen partners have argued the firm was scapegoated, that Enron's fraud would have happened regardless, and that destroying an entire firm for the actions of one office was unjust. Others insist the firm's culture had rotted from within, that the consulting revenues and client relationships had corrupted the audit function long before Enron collapsed. Both views contain truth, but they miss the deeper question: why did nobody see it coming? Thousands of Arthur Andersen employees worked on audits across the world. Hundreds of partners reviewed financial statements. Regulators examined the firm's practices. Yet the entire structure, an accounting firm transformed into a consulting business, auditing the same clients it advised, paid by the companies it was supposed to watch, continued unchallenged until it spectacularly failed. The answer may be that everyone saw it, but nobody wanted to acknowledge what it meant. Arthur Andersen's business model in the 1990s was the industry standard, not an outlier. Every major accounting firm was expanding consulting services. Every firm faced pressure to grow revenue from existing audit clients. Every firm struggled with the tension between skeptical auditing and profitable client relationships. Arthur Andersen's collapse forced the industry to confront that tension, briefly. Sarbanes-Oxley separated some consulting from auditing. Oversight increased, but the fundamental model survived. Auditors are still hired by the companies they audit. The Big Four still sell consulting services. The conflicts still exist, managed by rules and oversight, but never eliminated. In the end, Arthur Andersen's destruction answered one question and left another open. It proved that even the most respected institutions can vanish almost overnight when trust evaporates. But it left unresolved whether the accounting industry learned the right lesson or simply learned to be more careful about getting caught. The firm that built itself on saying no died because it couldn't say no when it mattered most. And 20 years later, we're still trusting the same system that failed to see it coming.